Hi again, this is Justin Lum, and I wanted to talk to you today about something that's been happening in immigration courts in the last year or two, but seems to be more prevalent now as immigration courts and the higher ups for immigration courts are starting to get a handle and an idea of what they want to do. So there is a situation where they literally say the higher ups, the people who are above the immigration judges, that they can decide that they are going to just dismiss a respondent's case in immigration court. And what does this mean? What this means is that the judge is not deciding it. You are not asking the government to agree with you, or the government is not asking you if you want to. The higher ups above the judges are just deciding your case should be dismissed. So what does that mean? As we've talked about before, if your case is dismissed, not administratively closed, then any employment authorization that you received in accordance with whatever your request for relief was, whether it's cancellation of removal or asylum, for example, will no longer exist, and therefore you will no longer have a right to work. Now, typically, the immigration courts are supposed to give you notice that their higher ups have decided that your case is proper for dismissal, and will then give you an opportunity to object and ask that your case be continued. However, if there's no objection made, if the government does, the government may also object, but if they don't object as well, then your case will be dismissed. On the positive side, you don't have a case before immigration court, and the government has elected not to pursue you. And then, of course, on the negative side is, if this happens, then you will no longer have a work permit. So that is something to keep in mind, that is happening now, where you don't even have to ask for a joint motion, and the government just doesn't decide. Well, a different part of the government decides. It's not the immigration court and not the government council.